Okay, hello everyone. This is He Jing, and I'm the partner at the GN law firm, and he's my colleague Sophie Song Hui. So first of all, welcome everyone for joining today's webinar. The theme of today's webinar is about the implementation rules of the patent law of China. We actually scheduled this webinar for especially for honoring my dear friends, my classmate, Professor Cui Guobin. Really acknowledge Professor Cui Guobin. Guobin, can you turn on your camera?
Okay, can you see me now?
Yes, we can see you.
Okay, very happy to be part of this event, great events. Thank you for your invitation.
Thank you for Guobin for joining us. In fact, that the content, what I'm about to present here, really based on two wonderful, really brilliant articles written by Guobin. So I said that we must have Guobin to be part of this program to really share our views about, actually also Guobin's views about this implementation rules of the patent law. And another purpose is that we actually do this intentionally in the English language. Very often that we do most of our webinars, very often on China's topic in Chinese language. But we thought that it would be really important to have more of our international colleagues to know more about the latest developments about this the very important rules in our patent system. So that's why we are doing this in English language. And then, well, if our Chinese colleagues are registering in this webinar, really enjoyed today's content, we're more than happy to do another session in the Chinese language. We're actually planning some more of the sessions in the patent law area in the near future. And my colleagues, Sophie and other colleagues will be really prepared to share some of our recent victories in the patent litigation and also the patent strategy in China. And we have plenty of interesting things what we want to share with all of you. So let's jump into the what we have prepared. I have this is slides. See, 1 second. We actually prepared a very long slides because the content is really a lot, but we're trying to finish them in about 1 hour and then leave probably 30 minutes for us to give some Q&A. Let me try this again. Okay. All right. So the topic is why it is worth the wait. In fact, that the reason is that this implementation regulations has been we've been waiting for 3 years. So today we're trying to see that hey, what is the real value of this implementation the regulations? Sometimes we call it the PLIR. Okay, when I say PLIR, it means that implementing rules. Otherwise, it's pretty long to say. We use IMR here. So either when we say IMR or PLIR, we really mean the same thing, the 实施细则. So if you look a little bit about the history, if you look at the history, our patent law starting from 1985, very soon after that, we have the IMR implementation regulations. Then we have another one, 1992. And then the latest version is really starting from 2001. That's really the version that China entered WTO. So the major changes were done to this the patent law and also IMR. Based on this version, on top of this version, and we have seen like the third, 3-time revisions, and the latest one was done on December 11th, 2023. This one has been really long wait. Everyone knows that we got this the patent law amendments done 2021. So we all thought that, hey, we're gonna have this implementation regulations very soon, but somehow it has taken us 2 or 3 years wait. Anyway, finally it's up. It still remains a little bit mysterious why it has taken too long. So hopefully next time it won't really make such a long wait. But now looking at this revision, we say, why so special? So first of all, it's really, I think that this feature line that implementing the national IP strategy, and also it really shows that the top leadership that giving all the attention to the IP system. It's a pretty long, it's adds about 26 articles, adding 2 chapters. And one chapter is about the patent term extension. Another chapter is about the design patent international applications. So the 5 major aspects, the patent applications, and make it easier for applicants, the innovators, the patent examination, the enhanced qualitative examination, the international rules, the patent enforcement, and also commercialization. So I think especially, again, I really want to acknowledge Professor Guobin. I know Guobin and the other professors and other leading thought leaders has been deeply involved in providing the comments, a lot of valuable comments, researchers to contribute to this implementing regulations throughout all these years. So lots of changes have been done, lots of improvements has been done to our patent law system. This really takes a lot of work. So today we're gonna do some very bold experiments. This is actually a good summary of the major changes that were implemented through this implementing regulations. This again based on the 2 articles written by Professor Cui. And we're going to really just go through them one by one. So we hope that everyone will get a sort of a fairly good idea about what's really in this implementation regulations. So actually, I want to reset in the very beginning, what are my most notable changes, okay? What I noticed, some of these are really my favorite, but some of these are sort of, we've been watching for years. Some of the changes are what we're looking for. Some of the changes are a little bit surprising, actually quite surprising, but these are really the notable changes. Later on, maybe I'll just ask my friends, Guobin, to say what are his most notable changes, and also ask my colleague Sophie what are her personal favorite, personal notable changes. The first one is actually the good faith principle, 诚实信用原则. Now it's actually could be basis for invalidation. This wasn't really a big surprise, right? This was already in the patent law, but now becoming official. So we're all looking forward to that. I have to say, in the recent years, we can see this very general principles like a good faith, like 诚实信用原则, and this kind of quote unquote ethical principles are playing a much bigger role in China's IP legal system. Similar things happening in other areas of law as well. We say that the ethical considerations, the moral considerations are playing bigger role in our Chinese legal system. This is actually a very interesting phenomenon that we have evidenced in Chinese the legal system. Another one is a patent term extension. This was very interesting changes done by the patent law. We've been all looking forward to see, hey, what are the detailed rules, especially for new drugs, the pharmaceutical patents. There's some interesting surprises that was there, and I even personally made a mistake in the understanding, which we're gonna talk about more about it. And I know I saw some familiar names, friends in today's audience. You're all welcome to be part of it. I saw Mr. Otto and then Donald Chan, I know some of you may not really do the pharmaceutical patent work, but the patent term extension, but what's really behind the patent term extension changes are probably really worthwhile watching and considering. The service invention, sorry for the typo, it's not a service intention. It's a really service invention, employment invention. There are actually big surprises there. The partial designs, that was not really a big surprise, but there's something, it's my personal favorite. We've been looking forward to the partial design, talking about it for over 10 years. So when we see that it's finally in place, it's quite exciting. The ex officio examination by CNIPA, by Patent Office, is not a big thing. And I thought that it's a very interesting move by our Patent Office. Not very surprising, but it gives lots of power to our patent examiners in the patent prosecution. So this is something that is probably going to have some big exchanges, big changes that are to our patent prosecution process. So we're going to highlight a bit more. So I just want to throw out these are my most notable changes, but I'm not saying these are the only things you should watching out. But just really because a lot of things are done in this by this implementing regulations or rules. I just want to give something that I personally watch out for a long time. So next one, first of all, the good faith, 诚实信用原则. By the way, this is the slides can be provided to our audience if you're interested. And then part of things that we're trying to do is that we're listing out a lot of these provisions, so you can actually really see that what's really in the law and what are really being said in the rules. So you can read and really watch and then making your own interpretation. First of all, the good faith principle was really codified in the patent law. And it's very interesting that the law now requires when you file the patent examination and enforcing your patent rights, you got to really comply with the good faith principle. And the patent owners cannot really abuse their rights to harm the public interest or the other lawful rights and the interests. I'm actually certain this provision may prove to be much more useful than what the legislators was imagining. Lots of things might be happening in the future because such general principles, general quote unquote ethical or business ethical rules can be litigated. We saw something similar in the trademark law area as well. So the major implication is that it can be used for the invalidation. It actually also be used for the open licensing statements. And the open licensing system is an interesting one in China. I personally have never done that before. For under this new provision, if someone acting in the bad faith, they cannot really benefit for the fee reduction benefit introduced by the open license system. And if someone violates this good faith principle, the administrative authority can even impose a fine or issue a warning. So there's really a legal consequence. There's a penalty for violating this good faith principle. So there's someone really noteworthy. The next part is that we just want to highlight that this is the good faith principle is really continues a tradition in a way that China's patent office has been fighting against this what we call 非正常专利 abnormal patent applications. This is a very interesting trend or trend in the last few years. For years that everyone in the international community knows that China being the patent filings in China really increased very, very rapidly. Probably because of this huge volume of applications, the patent office also noted the problem of this abnormal applications. So there's some quite heavy-handed approaches, consequences being implemented to deal with that. So I think the principle good faith, the 诚实信用原则 are properly introduced to fight against those low quality or bad patent applications or other type of applications are apparently motivated for non-innovative purposes. again, what is counted abnormal, what is counted normal, sometimes have some controversies. Some patent prosecution lawyers, even including ourselves, are sometimes struggling. What should be prosecuted? What kind of claims that we should go forward in the day-to-day the patent prosecution practice? So this is something we're always learning in practice. The next one, this is a delayed examination. This is looks like something maybe something not noted by lawyers that don't do the patent prosecution. But interestingly, this shows that our patent office gives some flexibilities in this area. Under the current patent law, that there's no provision for delaying the patent examination process, but everyone has to seek the substantive examination unless within 3 years, unless you withdraw it. So CNIPA can even initiate patent examination when needed. That's why this is the current the status. Nowadays, applicants sometimes can say, "Hey, we want to expedite examination." That's what has been happening. But the delayed examination wasn't really available. So this time you can see the patent office basically, okay, we give you a special treatment. If you want to defer it, delay it, you can defer the examination. So that's give the benefits. I'm probably not gonna say too much about the benefits. I think everyone doing the patent prosecution knows that sometimes we just have some strategic thinking, saying, hey, we don't want to the examination to be examined now. Okay, so it's just give more opportunities for the patent owners. I always hope that our patent office can give more flexibility to the way we can amend the claims. When the day happens, that's probably gonna give more. That really can give more opportunities for patent lawyers in China to demonstrate their expertise and the talents. The next one is the priority right system. This one is a little bit technical, but basically, when China has this foreign priority, when we have the domestic priority rights, design patents are somehow excluded. Was given some discriminative, so quote unquote discriminative treatment, but now this is coming back to our system. So priority rights, it's now available for design patents. So this probably shows that our legislators really trusted in the expertise of our Chinese ability to build our industry designs. This is actually really true in our own experience. We've been actually working with more and more local Chinese inventors. The designs are something that our Chinese applicants having a strong capability. I'll just skip this part. This is just really using this the detailed rules to showcase what are the changes. The next one is the design patents. Design patents is a big, the amendments of design patents related area is a big thing in this the patent law, and then without surprise also have a lot of changes in this implementing rules. China finally joined the Hague Agreements, International Industrial Designs. This is again a big change that really demonstrates the government's commitments to give much better protection to designs. So we now have a 15 years, the term of the protection under the Chinese law. And also we have the design protection for partial designs. Again, this is a partial design, the calling for better protection for the partial designs has been going on for decades. So it's now becoming true in our practice. So I think I recently spoke to some colleagues in this area who all agree that the design protection are probably at the forefront of our practice, not just in China. Even the design protection, the way we prosecute design patents for US, how we handle the designs for the European markets are probably should be more and more interesting. This is an area that our lawyers, patent prosecution lawyers, need to pay more attention. Lots of these changes, I'm not going to go through them one by one. Lots of the changes are fairly technical, and then I think they all really reflect the established consensus in the design patents examination and the granting process. I wish that we could have a couple pages to demonstrate that, especially the partial design, the practice, but that could be a very separate topic for another entire webinar in the near future. So the partial design, it's very, very critical. I may invite my colleague Sophie later on to give some comments on this part. The next part is the number one is the open licensing system, 开放许可. I always joking with including Guobin and other colleagues said, hey, this is the only areas that I had never touched in my entire patent career. I never tried this myself before. So basically the open license system, I think it's probably borrowed in ways transplanted from the foreign system. I think it's from the UK system, if I'm not wrong about this. The basic idea is that our patent office encourage the patent owners to register their patents with the patent office and also publicize the licensing terms. And anyone who are willing to take the license, they can simply say, okay, I take the offer and I got the license and I pay the money. So it's pretty straightforward. It's more like a public offering. It's an offer to the public with the binding terms. So that's, of course, it's definitely a great idea. It's probably, if it uses properly, probably can resolve lots of problems. But sometimes I feel like the reality is probably more complicated. There's something we're all hoping that it can deliver the kind of desirable results as we all want. I know some of friends here doing lots of licensing business. This is, if you're interested, maybe you can talk to the patent office to chat about it and how you can make that work. We summarize some of the sort of the similarities of the differences. We say that some countries they offer reduced official fees in exchange for patent owners giving up unilateral pricing rights. I don't think China restricted unilateral pricing, but they do require the advanced disclosure of licensing terms. So some of the details may be worth really researching if you are curious about it. One thing is that again, the good faith principle is really introduced to the open licensing system as well. And plus the CNIPA, our patent office, may scrutinize open licensing agreements before the granting the fee reductions. So always one of the good benefits for the open licensing system is that the patent office agreed to reduce the annual fees. So that's one of the attractions to take advantage of the system for the patent owners. Lots of patents. I think lots of companies in China these days accumulated a huge, significant number of patent portfolios. Those patent annuities would be a very, very big burden. So if those money can be reduced in exchange for the joining the open license system, could be quite interesting. So the next one, the patent term extension system. This is one of my most noted areas in this patent implementation regulations. When the rules was passed, the only thing I was jumping at is the patent term extension. So first of all, when we come to the patent law actually provides two kinds of patent term extension. I remember when I started my patent prosecution career, my patent lawyering career back at about the year 2000s. I think that was about the similar time the US patent system started the patent term extension. So I always remember, this is too complicated for our lawyers. It's always our colleagues in charge of the patent docketing, the paralegals, they got to learn about this. We never learned about this ourselves. But interestingly, 20 years later, China followed the similar routes. So the two kind of patent term extension, or sometimes we say patent term adjustments, or in Chinese language, we say 补偿, right? Like compensation. So whatever it's called, we use this extension to cover all the different meanings. I know someone use adjustments, extension, and compensation. So basically, sometimes people using I think adjustments or extension to refer to the scenario in the delays in the patent part, granting. This really means that if the patent office takes much longer than what's reasonable in examining the patents, the patents office agree to compensate, right, to extend or adjust the patent term. Another type of delays, another type of patent term extension is more relevant to the pharmaceutical companies. So we all know that the pharmaceutical companies have to apply for the market approval for their innovative drugs, but that could take years. To be fair or to encourage the innovation in the pharmaceutical area, China actually amended the patent law back in the year 2020, in a way that the kind of time that used in the drug market approval can be compensated. So that's the two types of patent term extension as in the patent law. But the law wasn't really clear, especially when it comes to what type of drug patents can benefit from this kind of system. So we're all waiting to see what's really in the implementing regulations. So if we jump into this new drug, you can see that in the law, it wasn't really clear what's really counted as this new drug, and what kind of a new drug is entitled to the patent term extension or compensation or adjustments. Lots of discussions, especially that sort of reflect the local generic company's voice, or reflecting the policy considerations that actually want the drug price cheaper or more available. They basically said that well, we want to limit the kind of scope of the patents, the scope of the new drug that can benefit from this provision. How about only those quote unquote truly innovative drugs that are never launched even outside China? Okay, this is what we call global new or global first standard. We should making sure those non-Chinese companies, whether it's American or Europeans, if they launch their innovative drugs to cure cancer or other type of disease, only if they agree to launch that first or simultaneously in China and outside China, then they can qualify this kind of patent term adjustments. So that's one voice. Another voice is that well, it probably should not be so harsh. It's always that the definition of a new drug only means that locally new. As long as this kind of drug never launched in China, it should provide this kind of benefits or incentives to the drug companies. So you at least can encourage pharmaceutical companies to launch or to make available those innovative drugs in China. So the draft amendments that was introduced to the earlier version of the patent law has this kind of consideration, basically limits the new drug to those globally new innovative drugs, at least some of the discussion additions, but that idea was eventually dropped. And so the patent law is really left to be decided by the implementing regulations. So we're all looking at the implementing regulations. Now, in the earlier discussion of the implementing regulations, we saw the earlier draft released by State Council, which actually pretty much intend to say, hey, introduce a global new standard. And that's actually obviously caused lots of concerns that the global first standards, especially for innovators. So with that's why it's all becoming this very interesting sort of interest to see what eventually are going to be in the implementing regulations in the IMR. What's gonna happen? So that's why when the implementing regulations was first passed, we're all looking. I immediately jumping on the relevant route to say, hey, how they define the new drugs. Interesting thing is that the definition wasn't really there. So I thought that wow, some flexibility was given, and the new drugs probably gonna just mean the China new standard. But actually, that wasn't really the case. Under this implementing rules, the definition simply said that new drugs are to conform to the regulations. That wasn't really there. And then when we're looking at the patent examination guidelines, which was actually, I think, publicized a day after the new patent implementing regulations, that's actually using the global first standard, which is my interpretation. The reason is that it basically said that the innovative drugs or improved innovative drugs under the general understanding of the pharmaceutical regulations, those two new kinds of drugs are the global first standards. So unless the patent office somehow provides a new interpretation, we actually seen that the examination guidelines, which are not really the regulations in terms of the hierarchy of legislations, provides this very crucial standard for the new drugs. This is probably, it's probably disappointing lots of innovative drug companies. Of course, there's some other, the other stakeholders will welcome that change. I think the next part of the future changes is that, hey, by when the Chinese legislator may looking at the entire dynamics and willing to make the new change. So what's really interesting is that I personally find this very interesting is that if you're looking at how our legislature, the way the China legislator works, it's pretty revealing. For years, we were looking at the patent linkage rules changes in the patent law, and now we're looking at how our legislators looking at dealing with the new drug, the definition. You can see that our government takes a very prudent approach when our legislature sees that there could be big controversies. They tend to leave something more general, more open, the space. For example, our patent linkage, the rules in patent law, the Article 76, initially we saw that there's a 9-month stay period codified in the draft provision, but then it was dropped, okay? And the similar thing happened to the new drug definition. So we probably can predict in the future when the new big controversies are taking place around some of the key issues in the law, our legislatures probably gonna make some flexibilities. They may go for some quote unquote conservative position in the lesser ranked rules, okay, things like patent examination guidelines, but they leave enough room for the future discussion, improvements. So I think that's what we have learned from this round of the patent implementing rules changes. Of course, there are some unanswered questions. I'm not going to really go into the details. Again, we stole this from Guobin's article. So what are the eligible patents? What are the eligible patent? The drugs should be qualified for this patent term extension. There are some rules gotta be making gotta be issued to clarify. For example, what happens to those drugs that were approved, right, between the June 1st, 2021, that's effective the patent law, and the January 20th, 2024. what will happen to those patents that are probably expired between June 1st, 2021 and January 20th, 2024. So this may be an issue that some of our pharmaceutical companies, in-house counsel and outside counsels need to work harder on this. There's some minor rules like about limitation of number of compensations. So this is fairly technical, and then I wouldn't deal with that for now. Some of the things are clear in the rules. Some things may still not so clear. And also calculation and compensation period. So it takes so much true professionals to do this calculations. So next one, the service inventions. Service inventions was a very heavy topic about 10 years ago when the patent law was amended before. Now, at that time, people always discussed whether the patent law should dictate or make it mandatory in what way service invention or employment inventions should be rewarded for those inventors. Now, the current the patent law takes on sort of a voluntary approach, not really mandatory. In case that there's no agreement between employer and the employee, and then the law kicks in to provide some default rules. So this time we can see that the implementing regulations make some sort of positive changes. They slightly increase some of the remuneration or the reward. Originally from the 3,000, now it's 4,000 for invention patents. Now 1,500 yuan for utility model and the design patents in the absence of the agreements. For remuneration from the operating profits, but not less than 2% for invention, the utility models, and not less than 2.02%. So that's now what's the default in the standard, part of the standard in the draft, the version of the implementing regulations. But however, interestingly, the final version we've been seeing is that they actually changed something dramatically. In the absence of agreements, the implementing regulation says that the law on promoting the transformation of scientific and technological achievements applies. This is actually very, very interesting. It could be a very big change. Traditionally, the law on promoting transformation, scientific, technological achievements law, we call this 促进科技成果转化法. This is something most of us actually quite ignorant, because people normally think that, well, this is probably more applied to state-owned companies, to schools, universities, research institutes. But if you read in a deeper way, it could be interpreted in a way may not be limited to the state-owned companies or research institutes. It could have a wider implication. In that law, the actual percentage of the shared revenue is very significant. It's like 50% of the net income from the commercialization. So that's actually very, very big change. So although this would not apply in case you have the agreements, but we all know that in China, we have this general quote unquote fairness provision under our civil code. That means that if if a contract or agreement is grossly unfair, 显失公平 is utterly unfair, this kind of a contract could be invalidated. So if I'm an employee inventor, if I think my invention is actually very, very valuable, if I only got paid or rewarded a very small percentage, which is way, way, way below than the default standard on the implementing regulations, like this 50% of net income, I'm actually trying to bring a case to the Chinese court to say, hey, I'm entitled to more, okay? Now, I know that this kind of arguments has been discussed for at least 10 years. The last time when the law was changed, the patent law, we will talk about this scenario. I personally have not seen this kind of cases myself. Even if there are such cases, we have not seen any big precedents coming out of that court decisions. So maybe our worries or concerns are totally an illusion. Maybe this may never be the case. But I just do want to make a note of this, and hopefully we're all wrong. All the companies, institutes were taking care of the agreements in a way that no trouble gonna happen in the future. So another one is the role of the ex officio examination patent proceedings. This really means that the patent examiners, the patent office, can do the work on their own to make the decisions on the key decisions. Right now, of course, typically speaking, that normally the patent office would follow the rules of at the request. If you request me to do this or do that in a re-examination, 再审 or invalidation, then we're jumping on it. Ex officio examinations permitted in exceptional circumstances to address overlooked defects that could lead to a rejection or invalidation. So this time in the earlier draft of the implementing regulations, the version was speaking about both re-examination and invalidations should allow the ex officio examination. But eventually, I think the final rules only agreed that in re-examination, that ex officio review is allowed. So for the invalidation, it apparently for the invalidation procedures, the ex officio examination is still sort of kept in the cage. It has not allowed the patent office in that invalidation proceedings so much room to make such changes. So this is the area that we must really watch very, very carefully. At least even for the re-examination proceedings, that actually the patent office, the patent examiners were given a lot of power to exercise their own power, to combine the prior, to really jump into it, to actually reject the examinations, which wasn't really overlooked before. So this is something that I think patent applicants should be really watching out. Another one is the patent rights evaluation report system. This one more relevant to the utility model and the design patents. I think we all know that in China, design patents utility model were not examined. So it's more registration system. Of course, in the last decade or so, the Chinese Patent Office has been doing a lot more rigorous in examining the utility model and the design patents. The utility model design patents are obviously invalid, will be actually rejected. So in a way, we have a little bit like an examination, but it has not really totally cured the system, cured the problem. So that's why in the 2008, the patent law allowed the courts or administrative authority to request the evaluation reports to use in infringement disputes. This report serves as a reference for assessing the patent validity system. Now, and the new patent law expanding it is basically allow everybody to not interested parties, at least infringers, to proactively request an evaluation report. So that means that you can basically get some expert in the patent office to say whether this design patents or utility model is valid or not. So this is provides some kind of validity, predictability for design patent utility model. Of course, also make the patent application's job a little bit easier this time. Under this new rules, the applicants actually can ask for the evaluation report within 2 months of the patent grant announcements. It just means that if the evaluation report says not that valid, so they can choose not to pay the fees, not really having this patent eventually granted, not to pay the annuities. So that actually make the applicant's job a little bit easier, redress the uncertainty system. And plus, under the current law, all the patent evaluation report are publicly accessible for everyone to check. Another one is this enhanced protection of genetic resources. This is area that a lot of, again, pharmaceutical companies, probably actually not for just pharmaceutical companies, lots of industry these days really rely on the genetic resources. So in China, even back in the year 2000s, the law prohibits granting the patents that use genetic resources in violation of the laws and regulations. So, which means that if you don't disclose, and you will get into trouble to have your patents that use genetic resources to grant it. So this is obviously one area that closely linked to the national security. In the implementing regulations, the new one is expanded, is broadened the definition of genetic resources to include both the physical material to and to the information derived from the use of the generic resources. This is covers more, not just the materials. It also covers the information coming out of the resources. So this is areas that really need to be watched out very closely. We know lots of companies actually now working on their generic resources related to patents. So this is area that the patent lawyers should be very careful about. And then I think this is a line from the Professor Guobin. Probably lots of more complementary legislation need to come out in this area. I'll leave that to Guobin later on to comment. Last one, this is about expanded role of the Ministry Department's patent matters. This really means the CNIPA's power. One thing we have to say, our patent office for years has been playing a very pivotal role in building this pro-innovation system in China, in a way that our patent office now expand more and more their powers to enforce the patents. Not just enforce patents, really building more of work, building up their infrastructure to provide the data, provide the system. So this is a very crucial part. So we can see that implementing regulations that continue give more power to our patent office. One part that we are looking at is what we call the enforcement powers of the patent office. One category is that the national significance, for the cases of national significance, the patent office can directly deal with it at the central government level. So there's a new rule define what is the national significance. They also provide some jurisdiction that can be delegated for the local provincial patent office to deal with the kind of cases. We've been seeing a very, very proactive patent office in China. They have done some very notable work results. Recently, Huawei and Xiaomi strike a patent license after Huawei successfully filed the case, the patent infringement case, in front of the National Patent Office. I think a few months after they filed, a license was made between the two companies. So even though we don't know the backgrounds, but we are certain that that kind of involvement or intervention by the patent office in this kind of enforcement proceedings probably made a difference. So I personally predict that our patent office may jump in on more and more important cases in the future for enforcement purposes. This is actually gives, I think, some new strategic thinking for patent owners in the future to enforce their patents. So not at least, this new law actually also gives some rules, provide some rules to dictate how the patent office can provide like a data service, information service system, and we're thinking that these are all generally welcome in our system. I think what we prepared so far, and then this actually taken pretty long to go through them. So I will maybe direct to back to Guobin to make some insightful comments.
Okay, thank you. Can you hear me now?
Yes.
Okay, thank you. In 15 minutes, give a very good summary of the recent amendments to the implementing rules. I think it's very helpful. Here, I just want to add this to explain further on some important issues you mentioned in your presentation. The first one about the principle of good faith. I agree with you. Although in the implementing rules, they only mentioned in the future probably will apply this principle specifically to deal with abnormal applications or the abuse of open licensing regime. I agree with you, man. In the future, probably this kind of rule will also be applied in other areas. For example, if the patent does not cover the dependent's behavior, the acts, and then you know that still sue for infringement, maybe it's kind of misuse of your patents, right? In this kind of scenario, the dependent may apply this kind of principle to fight against the bad faith patent owner. In other case, for example, they keep sending this kind of baseless warning letter. I guess this kind of principle could help. That's the first issue on principle of good faith. And the second one, I think probably I want to mention is the open license regime. Yeah, I am happy you mentioned this kind of system probably is borrowed from UK or Germany or other European countries. Recently, to do a research, I find that France actually already abolished this kind of system in 2005. I don't know whether this kind of system in the future will work well under Chinese law. As you mentioned, Chinese law, Chinese rule is a little bit different from the UK and the German one. Under the UK or German law, if you file a registration before the patent office, say I want to go to grant license to everyone, but you don't need to disclose the license term in advance, right? But the Chinese one require you to disclose this one, and then still give you a freedom to set first the royalty rate for your patent. The UK or German law, they don't allow the patent owner to keep this kind of rights. Right? If the third party want to take a license and they could not conclude an agreement with the patent owner, and then the patent owner need to accept a price or royalty rate set by the patent office. So that basically means if you want to take advantage of this kind of system, you need to give up this kind of rights. The Chinese law does not have this kind of requirement. So that's give an incentive for the Chinese patent owner to cheat, right? You will still want to have probably half of your maintenance fee waived and still keep the right to set the price for your own patent. So in this kind of implementing rules, we create a lot of detailed rules to prevent the potential patent owner from abusing the system. I think it's very interesting. For me, I think that currently in this kind of the age of AI or internet, I think that's patent owner has no difficulty. The potential licensees have no difficulty in finding a patent owner, right? So I don't think this kind of system will really be helpful. That's my comment on the open license system. But for lawyers, it's a good system, right? Probably give a chance to help the patent owner to reduce the maintenance fee in the future.
Well, yeah. Well, this is something I never used that myself.
Okay, I think according to the statistics in Germany or I think the UK system, under the UK system, very few patents have been registered under this kind of system. I think each year only probably 2,000 to 3,000. I think a very small number, right? In Germany, it's a little bit different. I think in the electronic industry, probably more than 10 to 12% patent has been claimed under this kind of system. I guess in this kind of patent extensive area, the patent owner has this kind of financial pressure, right? So they want to, if they believe the patent is not that valuable, probably, but they still want to keep it, maybe they register as under this kind of open license regime, and then get some kind of weight from the office. That's the third issue on the second issue on the open license regime. The third one about the patent term extension system. I agree with all your comments. The Chinese one, I think initially the National People Congress refused to clarify the scope of the new drug, right? This kind of definition, and then the State Council refused as well. Now the ball is given to the patent office. The patent office in the patent examination guidelines still insist this kind of global first, global new standard. I think that probably will disappoint some international pharmaceutical companies. But the good news is, since they are now only the patent examination guidelines have this kind of definition, right? If in the future, if the decision maker believe it's proper to change, right? And then probably they could change the guideline easily. They don't need to pass the very complicated procedure under the state council's legislative process. That's probably the good news, right? The first issue about the service you mentioned, interesting. I think this probably is a last minute amendment, right? When the draft proposals sent to state council, they don't make any modifications on the service you mentioned, but later on, probably when the state council have that kind of internal evaluation, and then some top leader probably believe the current compensation or this kind of reward is not enough. So the patent office later on revised this article in a very short period, significantly increasing the standard for compensation or reward. Very interesting. When implementing this, when doing this kind of amendments, the patent office abolish the default rules, right, specifically, and then incorporate the Article 45 of the law on promoting the transformation of scientific achievements. As you just mentioned, that article, that law actually in the past did not cost too much attention from the patent community, right? So most of private industries actually do not treat that kind of law seriously. But all of a sudden, it was incorporated in this kind of patent law. And I think that's caused some kind of probably caused some concerns among industry, and also caused some kind of uncertainty. For example, they literally give a very high standard for compensation or reward, right? But on the other hand, they also require the employers to reward not only inventors but also those engaging in the transformation or commercialization of the technology, right? So the standard is pretty generous, right? Very high. But they cover two groups of people. One is inventors, another is probably I think the high level of managing officials, right, in the company. So in the future, these two group of people need to divide this reward or the compensation set by the law. How to do this? I think still a big problem. That's my comment on the service you mentioned. And the last issue about the official examination, in the practice, the patent office always could do this kind of official examination in the patent reconsideration or the invalidation process. today, even I think the patent guidelines still allow the patent office to do so, but they don't have a clear legal basis for them to do this. So that's why initially they want to adopt this kind of clear articles in the implementing rules to provide legal basis for them to do so. But this caused a lot of concerns. So later on, they abolish when the article relevant to the invalidation grounds. I don't know. That does not mean the patent office will change their practice. They will probably still do this kind of ex officio examination. But we don't know whether the court in the future will support them to do so. As we know, in some cases, the court don't want to the patent office to do this kind of ex officio examination in patent invalidation process, especially when the defects is in inventiveness. The court usually say this kind of defects not obvious, so you should not do this kind of ex officio action. I don't know whether in the future the court will still insist this kind of standard. It's a very interesting issue. Okay, let's stop here. If you guys have more questions or later on we could jump in. Okay, thank you.
Okay, thank you, Guobin. So I will invite my colleague Sophie. Maybe you want to sit here a little bit so people can see you.
I would like to add a special note about the partial design. As we know, Article 2 of the latest patent law explicitly introduced the protection of partial designs, aligning with the countries such as the United States, Japan, South Korea, and the European. In practice, many infringers often copy a part of a design, combine those highlights. And so to avoid this, patent holders often need to apply for many design patents for both the overall products and the specific aspects. So the new amendment is beneficial for the comprehensive protection of the designs and also reduce some cost for the patent owners. But on the other hand, we think the partial design system also carries a risk of right abuse in China, since in China, design patents are not subject to substantive examination, unlike the United States, Japan, or the South Korea. So the volume of the patent applications is very huge with poor stabilities. So there has already been a trend that the right abuse of the design patents in practice. So on this basis, the protection scope for partial designs is broader and the right are less stable compared to overall designs. So we think it's necessary to develop a whole application and protection rules that match the features of the partial designs to prevent harming public interests. So for companies, we think the cost of FTO may be higher, although they can reduce the cost for patent applications, but higher for the FTO and require more effort to challenge the validity of the prior design patents. That's what I want to add.
Great. So I think I don't know if any of our audience want to ask a question. I think if you want to ask a question, you can put in a line in the chat box. I think you can do that. While we're giving people the opportunity to ask questions, Guobin, I don't know, what are the sort of the most exciting change in the implementing regulations to in your perspectives? Something that you really like. I wouldn't ask you what are your things you don't like. What are your most favorite?
For me, I think probably the most interesting amendment probably is about the delayed examination. I think it's really beneficial, right? For the give all the patent owner probably more additional 3 years, right? To see what's going on in the market and then determine how to draft your claims. I think that's really a good move.
Yeah, yeah, that's very practical. That's very practical.
Yeah.
Tools that are offered. That it's a looks like a small thing, but it could be very useful for patent applicants.
Yes.
Mm. What about you? What are your
Favorite.
yes, favorite? Notable, most notable.
Notable aspect may be the open licensing system. We think I think this provide some opportunities for the research institutions and the universities to give them a place to show their willingness to license their patents and prevent patents to as always fall asleep.
Yeah, I think it's probably not only for university, probably, but like Huawei or ZTE probably are also pretty happy, right? Because they give that opportunity to reduce the maintenance fee. But the Chinese rule is very rigid because we are worried about some fraud or cheating from the patent owner. So we require the patent owner to sign the license agreement in advance, and then you show this kind of evidence of this kind of a transaction to the patent office, and only after that the patent office will waive this kind of administrative fee. So it's pretty rigid. I think in practice it's maybe still pretty burdensome for patent owner to get this kind of benefit.
Yeah. Guobin, what are the actually the changes you want to see but did not show up in this implementing regulations?
Probably I think the patent prosecution procedures, we need to do some, I think, substantial reform. For example, whether we should whether we should allow the patent owner to narrow down his claims, right, and not simply delete existing claims. I think that's a very important rules. And if the patent the patent office want to do this, you should probably put quite complicated rules in this kind of implementing in the regulations.
Yeah.
And also I think the invalidation, the patent invalidation procedure, you probably also need to do some reform, whether the patent office should be dependent, something like that. I think this kind of reform is pretty important, but probably too controversial. So we don't do this time.
Yeah. Well, those are two areas, especially claim amendments. I think our country really need to have that, give more flexibility. This is the time to improve, right, the skill sets or to honor the skill sets of good patent prosecution lawyers. Right now, the patent examiners are better trained. I think the examiners these days they are better trained. They have more time to handle the cases. So they should be given more challenges to deal with all sorts of claim amendments. I think right now, Chinese companies have new iterations and iterations and iterations. Every iteration is new round of patenting, and we should really find a way to improve the quality of patent prosecution. So I think claim amendments are very, very critical.
Yeah, and also, for example, whether the Chinese patent office follow the same rule to interpret claims when doing this kind of patent examination or patent examination, right? I think whether they follow the same rule taken by a court is also a pretty important issue.
Yeah, that's another big area for the future improvements. So, yeah. What about Sophie? What are the rules you're hoping that may show up one day in the implementing regulations?
One day, not so particular, maybe some specific regulation about the examination or the validation procedures.
Okay. Well, Sophie has done years of prosecution work before she's now jumping on the invalidations. Actually, the last few days, I was watching some videos offered by Berkeley to making up my California bar requirements. We have the continuing legal education. One part is about the AI patenting. Apparently, in the US PTO, the AI related the issues becoming a bigger and bigger, and more patent lawyers are now relying, even using the ChatGPT to draft up, or the GPT related the apps to draft up patent specification. So people just demonstrate right away to say, hey, they input in like 2 pages patent claims and put in the system, the AI system, then right away generated like 20-30 pages of specification plus drawings.
Yeah, I think that's actually already a big issue. In the copyright area, we have the similar controversy, right? Whether AI generated content is copyrightable. In the patent area, I think the controversy is almost the same. If you use AI to help, and the AI will easily generate quite a lot of inventions, how to examine or to deal with the non-obviousness issue. I think it's even the novelty issue is a complicated one. Whether we should treat the AI as part of prior art, I don't know. We will have here at Tsinghua, I have some students doing research on this. They come up with some proposals like, if only you own this kind of AI, I think the skilled person does not have this one. Maybe you still treat this kind of invention come from you, the developer of the AI. But if everyone owns this kind of AI, maybe we treat this kind of AI as part of prior art. Whether this kind of rule really work, I'm not sure.
Yeah, well, that's probably in 10 years, we're gonna see the new round of changes in the law and regulations. Okay, so I have not seen any questions from our audience, but I really appreciate our audience staying late for this webinar. Really appreciate it. Hopefully we can see all of you next time. And I really thank you, Guobin, my friends, for supporting this program. This webinar is really honor your 2 articles.
Okay, thank you. My great pleasure.
If you agree that we may post a video of the recorded seminar somewhere and on YouTube or somewhere to have more of our friends in the international legal community to watch it and know more about our patent implementing regulations.
Okay, no problem. More than happy.
Okay. Yeah, your permit is now recorded. We got the license. Okay.
Okay.
Thank you. Thank you.
Okay, thank you. Bye-bye.
Again, thank you all the audience for being with us.
Bye-bye.
Bye-bye.
Bye.